I'm Lauren Noyes, Executive Director of Faith and Law, and I cannot tell you how wonderful it is to be back here in the Rayburn building. It is literally, I think, 2 years and 1 week since we have held Faith and Law in the Capitol complex. And before that, we had been holding Faith and Law in the Capitol complex for, 36 years. So, I just am so happy to be back here and see friendly faces that we haven't seen in a while. Wonderful to be with you all today. And to just be in this beautiful room. I am so grateful to Stephen and his team for opening up this wonderful room to us, for Mary and for Ransom and for Joe, who have made this happen today. So thank you guys, a little shout out to you. All right, so I also am grateful to the Institute for Human Ecology at Catholic University of America that is bringing us here today, Bill Saunders and his team. And you are here to hear the Dobbs case. Is abortion a right without a constitutional foundation? As you come in, we are a casual group. Just grab your food and find a seat. For those of you joining us for the first time today, and can I get a hand raise if you are here at Faith and Law for the first time ever? Anybody? Oh, only a few. Wow. Well, let's get the word out. That is one thing that we need to do now that we're in a different season here and things are opening up again. Invite your friends, tell your colleagues, and I can't tell you how often I hear from people on the Hill, oh, I've been on the Hill for 5 years and I never heard about Faith and Law and I sure wish I knew about it 5 years ago. So please, when you get our invitations, share it. But if you are joining us for the first time today, we were started 39 years ago for the purpose of equipping and encouraging Christian policymakers to more fully understand the biblical worldview and its implication in their calling to the public square. Today, we continue our mission as a community of congressional staffers and members of Congress that meet regularly to think deeply about how our faith informs and impacts our calling to the halls of Congress. We like to say we do not know exactly what God thinks about healthcare or tax policy or transportation policy, but we do firmly believe that God cares about it and that we should look to Him in a community with other believers to live out the credo of Abraham Kuyper. There is not a square inch in the whole domain of our human existence over which Christ, who is sovereign over all, does not cry, "Mine." Let me tell you about a couple of upcoming events that we've got going on. Next week, March 24th, we've got a house reading group and an intern reading group meeting. So if I know interns are really looking for some in-person things to go to, our intern reading group is a great place to go. If you know of people who are interested in either a house reading group, if you are a full-time house staffer, you qualify for the house reading group. And these groups get together, they ahead of time read an article or a series of articles on a particular topic, and then just come together over lunch that we provide and discuss it. So let me know if you are not in a reading group or you know someone who needs to get in one, and we will get you on the list. Then next Friday, March 25th, we have John Stonestreet, who is the president of the Colson Center for Christian Worldview. He is going to be speaking to us, and you're not going to want to miss that session as well. And then the following week, April 8th, we are partnering with Prison Fellowship for a session on advancing a culture of second chances. So that'll be related to criminal justice reform. So I hope you'll come to all of those. We typically meet as Faith and Law for these larger groups twice a month. We try to do once on the House side and once on the Senate side each month. I am currently working on getting a room in the Senate side, and I went over there yesterday, and I have high hopes that we're about to get one. So that'll be exciting for those of you who traipsed across the Capitol. All right, I'd like to now, I was so excited to see Father Gurney come today, and I would like to have him come up and open us up in prayer. Father is, oh, no? Oh, he's closing. Oh, I messed it up. Sorry. He's going to close us in prayer, so I'll tell you about him later. And right now, the president of the board and chairman of the board and co-founder of Faith and Law is going to open us up. This is John Pelafudis.
Let's pray. Heavenly King, we thank you for the great privilege of meeting in this room. We thank you also for the great privilege of serving you in this place. We pray that we would be men and women fit to serve you and your kingdom. We thank you, too, for your grace and favor in the lives of Professor Saunders and Professor Alvaré. We pray that that grace would flow out now, their knowledge, their insight, and their commitment to you. For we do indeed pray to you, great King, great Savior, Jesus Christ our Lord. Amen.
Amen. All right, on your sandwich, you should have seen a QR code on a sticker. Would you please do me a huge favor and take out your phone, which I know you guys have on you, and open your camera and put it on that QR code and tell us that you're here. It really helps us to get registrations from people so we can know who joined us today and make sure that we have contact with you. So please do that. Don't forget the QR code. All right. Now I am excited. I want us to get going on this program. So you may have heard of the Institute for Human Ecology, but if you haven't, they are at the Catholic University of America, and they are the leading academic institute committed to increasing the scientific understanding of the economic, cultural, and social conditions vital for human flourishing. IHE program challenges the deterministic and reductive institutions' arguments that thwart the pursuit of greater freedom and prosperity for all. And Faith and Law has the privilege of partnering with IHE 4 times a year to bring these sessions to you. So today I would like to welcome Dr. William Saunders, the director of IHE's program in human rights, and Professor Helen Alvaré, the Robert A. Levy Endowed Chair in Law and Liberty at the Antonin Scalia Law School at George Mason University, where she teaches on family law, law and religion, and property law. So, Dr. Bill Saunders, I give this over to you. Thank you. Let's welcome her.
Hello, everybody. Thanks for coming. Let me just tell you 2 seconds about the program that I direct at Catholic University. And for those of you that don't know, it's just 2 metro stops north of here. And eminent people like Bill Wichterman, who is one of the founders of Faith and Law, got a graduate degree there. So I know many of you are not Catholics, but don't worry, non-Catholics are welcome to get graduate degrees, and we'd love to see you. My program is in human rights from the Catholic perspective, and I know that many of you who might call themselves conservatives might not believe in human rights. Let me just tell you, because it's been captured by the left, but let me just tell you what we mean by that is, frankly, a Christian orientation to human rights, which is a reflection of the dignity of each human person who's been redeemed by Christ. And that is the dignity we seek to recognize and protect in human rights. So you're welcome, any of you that want to inquire on graduate work. Our website is MA Human Rights, MA like Master of Arts, mahumanrights.com, and you can find any information. So one of the rights, of course, and the most fundamental right is the right to life of every human being. And so it's my pleasure today to have Helen Alvaré with me to talk about the legal status of protection of the right to life. As you all know, Roe v. Wade and subsequent cases have given a right to abortion, and that is under reconsideration by the Supreme Court in the Dobbs case. I assume you're all conversant on that. I won't go into details, but the main thing is it's a Mississippi statute that bans abortions after 15 weeks. And the question is it constitutional? And whether or not it's constitutional depends on whether the court wants to continue to follow existing precedents or to reverse them. So I think you got a good introduction from Lauren about Helen. I would just say I've known Helen and worked with Helen for many years. In fact, she was a pro-life spokesman and lawyer at the Bishops' Conference for many years while I was working in nonprofits here in D.C. She really is one of the leading experts on this whole area of law. So we're going to start off, she's going to talk to you a little bit from her perspective. I'm going to give you a little bit from my perspective, We're going to talk a little bit, and then we're going to open up to you. So, start thinking of your questions, because we're going to have at least 15 minutes of questions. So, Helen, let me turn it over to you.
Thank you. Thank you so much, Bill. It's been an honor to work with Bill. One of the cool things about the pro-life movement, we get caricatured as sort of idiots. They used to call me a female impersonator for a while, too, which is really funny when feminists call you that if you're pro-life. But there are so many people who are so highly qualified, like Bill and others, who work together. I mean, we really do bring together faith and reason at a really high level. And it's just been my privilege to work with these folks, really since the late 80s. So thanks for being here, and I'm really anxious for your questions. Being a professor, I want to make sure you leave with what you need to know about this. What I thought I would do is, I'll tell you about the existing state of the law, but I'll tell you why. There's very few things that are as definitive as this. There just is no right to abortion in the Constitution. And I'm going to explain to you legally why that's the case. I'm going to do it from two perspectives. One is due process, which I'll explain in a second. The other is equal protection, because people have been urging the court, if they back off of the due process grounds for abortion, to base it on equal protection. So I thought I'd equip you with both. The equal protection argument, myself and a couple of other lawyers, Elizabeth Kirk, who's at Catholic U's Law School, Teresa Collette, Erica Bakayaki, we put together a brief of 240 women, JD, PhD, MDs, who made the equal protection rebuttal argument at the Supreme Court in Dobbs. We had a really good time doing it. If you could call my getting up at 4 a.m. every day during my alleged vacation to put together the data a good time. So I'm just going to say yes. So let me just tell you, currently, Roe versus Wade, 1973, grounds a right to abortion in what we call the substantive due process of the 14th Amendment. 14th Amendment says that the government will not deprive people of life, liberty, or property without due process. Sometime in the 19th century, in addition to process, you get to know the charges against you. If you've been accused of something, you get to face your accuser, that sort of process. The due process clause became imbued with what we call a substantive component. They could have used the 10th Amendment, things that are left to the states, liberties that the Bill of Rights did not itself define, but everybody gets that the people have. It's not like the people who sat down and drafted the Bill of Rights could dream up all the liberties that human beings have and then, squeeze it into 10 amendments. So they could have done it there, but they decided to recognize these liberties in what they called substantive due process of the 14th Amendment. Interestingly, and I've got a paper coming out on this one as well, some of the earliest ones were the rights of parents to educate their children. These were the 1920s cases of Pierce and Myers. In 1973, the Supreme Court says that it's going to include abortion as a due process right under the 14th Amendment. And what do they mean by this? Well, not something very legit. What they had said before was that it's no business of the Supreme Court to be finding unwritten, non-textual liberties in the Constitution unless there was a lengthy history and tradition that these liberties were recognized in the United States, okay? Because otherwise, it would just be the preferences of 5 out of 9 members of the court could declare something is a liberty, okay? Despite this test, they completely ignore history and tradition when they decide that there is a right of abortion in the Constitution. Let me segue over to equal protection, then come back and address them both. Even though they didn't really have a substantive due process argument in Roe, and some people recognize that it was quite thin, by the time the Supreme Court comes down in 1992 in the Casey decision and reaffirms Roe, sort of, they rejigger the test a bit, but they still say the Constitution contains a right of abortion. It begins to be suggested by Sandra O'Connor at that time that maybe abortion could also be grounded in equal protection. That is to say, the claim that women could not be equal unless there was a right of abortion. There's a line from the movie Freaky Friday, which you may or may not have seen, at which point when the daughter becomes the mother, she says something like, "I'm going to be consigned to a phoneless, dateless Amish existence." And this was sort of the tone of Sandra O'Connor's plurality in Casey, and of Justice Ginsburg's dissent in the partial birth abortion case in years later in Gonzalez versus Carhart, where she says if women don't have abortion, there's just no social equality possible. They won't be able to work. They won't be able to be perceived as equal with men. They won't be able to earn. They won't be able to go to school without abortion. This is the basis of the equal protection argument. Now, just allow me to demolish each of these for you, okay, with some facts. Because part of being Christian, right, is understanding that God creates the world and everything in it and gives us reason and gives us facts to use, and we should use them because it's actually very disrespectful of democracy, of reason, not to use the facts that are out there. So I'm going to stick to my little text here just so I can give it to you in a short order. I usually, roam around in my thoughts, but since we have limited time. So the Supreme Court has swung wildly in its articulation of the test for what is a non-textual substantive due process right, okay? The test most respectful of a democracy, that is, what we the people have chosen in the laws of our states and our customs, and the Supreme Court later looks at and says, we recognize that the people have chosen this as a liberty, is a test articulated by the court many times, including in two cases in particular, Moore versus City of East Cleveland and Washington versus Glucksberg, which was a case about a state banning assisted suicide. These called, in order to determine a substantive due process right, for a, quote, careful description of the right and a naming of only those that are, quote, deeply rooted in our history, legislative tradition, and practices, okay? There are tests that the court has articulated that are far less respectful of we the people. These would be Justice Kennedy's tests, okay? Which is sort of like, I'm just going to say blah, 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 whatever. I mean, I just cannot say it any more clearly. These were said in the Lawrence case, which found that same-sex sexual relations were a fundamental constitutional right out of the 14th Amendment, and his Obergefell test, which said that the right to same-sex marriage was also deeply rooted in our Constitution. What did he actually say were the tests that he used to find these two rights in the Constitution? These were, he said, in the context of Lawrence, whatever the European Court of Human Rights had done lately and people's current opinions. Okay, that's what we determine is a substantive due process right. Obergefell, it got even weirder. It's like, let's not look at what people have done recently because like 34 states had recently voted to reaffirm marriage as an opposite-sex institution. Let's not look at what Europe has done because Europe had affirmed that nations' rights in the European Union to affirm marriage as an institution between men and women was within countries' margin of appreciation, and there was no human right to articulate same-sex marriage. And let's not look at history and tradition at all in what the country had done since its inception. Instead, let's look at what 5 of 9 members of the court thought was reasoned judgment or what their understanding of liberty is now. Okay, so these were the various tests. So now let's look at the best test, the one most respectful of what we the people have determined are our liberties, and apply it to abortion. If you look at what we the people determined was our law, either at the time of the 14th Amendment or even right up to the time of 1973 when Roe versus Wade came down, you'd find the following. Since the origins of the country, unborn human lives have been protected since medical science could determine they were alive. Before the early 19th century, this meant protecting them by, from the moment what they called quickening, when the mother could feel movement. Why? Not because they denied life existed before, but because if it came to an evidentiary showing at a trial, they needed someone to be able to say they knew the child was alive and then was no longer after the abortion. So quickening was the evidentiary standard. However, when science discovered the ova and the events of fertilization and concluded that new life began at fertilization, the abortion laws changed rather rapidly to reflect this new scientific standard. In 1859, the American Medical Association, which today is explicitly pro-legal abortion for all times, for all reasons, dismissed the fiction that human life was not alive till quickening. In 1868, when the 14th Amendment was ratified, with the Due Process Clause in it, 30 of 37 states had put in their legislative codes common law protections for unborn life, all but 3 from the moment of fertilization. And then in the years between 1868 and 1886, every single state and territory protected human life, almost all from conception. That was the history of the 14th Amendment. And even when we come now, you know, in the Supreme Court's opinion in Roe versus Wade, they had no factual findings at trial. You realize there was never any presentation of facts. They literally took them from Justice Blackmun's roaming around in some medical research, and then all the historical facts, all of them, were taken from an amicus brief written by a lawyer who was formerly the general counsel of the National Abortion Rights Action League, Cyril Means. And the entire history of abortion law in the U.S. was lifted from an abortion supporter's amicus brief. He claimed that the only laws in the United States that they all were about protecting human life from quickening because nobody actually thought there was any human life before then. He completely left out a discussion of the events of conception and the changing of laws to reflect around the time of the 14th Amendment when human life actually began. He also neglected to mention that even after abortion became dramatically safer in the 1940s, when they invented antibiotics, abortion got much, much safer. That even then, abortion was forbidden in every state for almost all reasons and almost all times, okay? Even though his argument was that the only reason that abortion had ever been forbidden was because it was unsafe. He also ignored 60 abortion decisions in the Supreme Courts of 42 states that named the protection of human life before birth as the leading reason for the passage of the laws in the states that had them, which was every state. I mean, it was absolutely a manufactured history, okay? I urge you to read a book by Joseph Della Pena, who, despite his Italian last name, says in the beginning that he is pro-choice and Unitarian, and he has written the definitive history of abortion laws in the United States. It's really the book, okay? Even if we consider the trajectory of American laws in recent times, and you ask, who is the United States? What is our tradition on the laws on abortion? If you look at the collection of laws, bills, laws on abortion that have been attempted in the United States since 1973, you can find these in the Guttmacher Institute or the National Abortion Rights Action League collections, that year in and year out, every year since Roe and Casey have commanded every state to permit abortion for all times and all reasons. Several hundred pro-life bills are introduced in the United States every single year. 561 measures have passed in state houses just in 2021, and 1,321 pro-life laws since Roe. Okay, so that is not a history and tradition of a depth of approval for abortion. It's just the opposite. The picture of abortion law in the U.S. doesn't even meet the whatever tests of Lawrence and Obergefell. Lawrence wants to know about recent trends and about Europe. But recent trends, as I just described, are pretty pro-life, or at the very least, they're mixed. You do have some states passing abortion on demand laws. In Europe, the European Court of Human Rights, as I said, has held that abortion is not a basic human right, and that states in the margin of appreciation can extend protection to life before birth, which many have extended protection. What about Justice Kennedy's wildly subjective reasoned judgment about liberty, okay? Or his other test in Obergefell, new dimensions of freedom that become apparent to new generations. I'm sorry. I mean, that's just a whatever constitution. It's ridiculous. And no matter what people feel on these issues, you should be cringing that people are allowed to interpret the Constitution in this way. Even if in what he did in Obergefell we were to do regarding abortion, which is he consulted closely public attitudes, you can see that the public is about evenly divided on labels on pro-life and pro-choice. And they are more in the pro-life camp when it comes to actual laws on it. What about legal developments? I've just described to you hundreds and hundreds of attempts to pass pro-life laws, many successful. He also says that a court should, quote, exercise reasoned judgment and better informed understanding, in the course of which history and tradition guide and discipline the inquiry, but do not set the outer boundaries. I know, it's ridiculous. Everything about history and tradition is on the side of a country that does not favor widespread abortion. Everything. There is nothing up through Roe, up through Casey, or past that does not indicate that the country is not, at the very least, mixed in a dramatic way. By no means abortion on demand throughout pregnancy. Let me just do a couple minutes now on an equal protection argument, and then I'll stop. So it became, as I said, suggested by the plurality opinion in Casey and Justice Ginsburg really pushing it in the Gonzalez versus Carhart case, that they wanted to put abortion on a new, what they thought was a stronger framework. Everybody recognized this. The due process framework was a joke. Okay, so they wanted to move it over into a new place where they thought it could be more secure. Justice Ginsburg had written about this separately, actually, in a Supreme Court opinion, or in a law review article she was pretty famous for. So let me say a couple things about this argument. First, no actual argument has ever been laid out on this by the court. There were 2 times where it was cited, and in both cases, and this just kills you if you actually care about facts. In the Casey case, a footnote was dropped to an article by a very rabidly pro-choice political scientist who in her book did not say, the book that was cited, the pages that were cited, she did not say that abortion had led to women's better social position. She actually said women's rising equality, educationally, economically, and everything, had led women to be able to make the demand for abortion. So she actually made reverse causation. Fascinating. Likewise, in the Stenberg versus Gonzalez case, they cite Reva Siegel at Yale. Nothing empirical in that either. Basic statements, also a claim of reverse causation. So they have nothing in their arguments, which is, I shouldn't be stunned to discover it. I did some research on the contraception mandate and the Institute of Medicine report that supposedly medically supported that and kind of blew that out of the water in a 70-page detailed examination of their sources. Always have fun with their arguments and their sources. You know, be the smartest person in the room, ruin your vacations, get up early, do the data you need to do, because in the end, the feeling of victory is awesome, right? When you have your facts in a row, okay? It's worth it, okay? Second, any argument linking abortion with women's progress would have to take a far more intensive investigation about women's mental and physical health as a result of abortion. I was on an NIH panel, the National Institute of Child Health and Human Development, for years that looked into the ethics of things. And I kept asking, why don't you attach questions to your questionnaires about how women are doing after abortion? You know, we had it at that point 1.7 million times a year. Now it's down to, who knows, 700, 900 a year. It's not fully reported. It's voluntary reporting in many places. And they had no study of it. So I recently had a student go and file a formal question with NIH. Do you have any studies indicating the relationship between elective abortion and women's health? And we got back a statement that we have, quote, no studies on the subject. Really? 700, 900,000 times a year women undergo this and they're not even curious? Okay? And yet, I will tell you, and it's all written in a law review article or in the Supreme Court brief we filed in Dobbs, and I'd be happy to give you those sites, there's plenty of studies overseas. Random controlled trials, excuse me, I should say not random controlled trials. They are register linkage studies where they looked at women from the time they were born to the time they died and the effect that the abortion seemed to have on their trajectory, okay? And those studies indicate problems, which we are not even care enough about women here in the United States to study at our own NIH with its many, many billions of dollars of funding. Third, and finally, as I argued in my Dobbs amicus, during the years from 1990 to today, abortion rates and ratios, that is, numbers per 1,000 women and numbers of abortions per live birth, have gone down by about 50%. During that time, you look at every major indicator of women's social progress. And I will just give you a couple of figures. The percentage in the workforce with college degrees. During the time abortion rates and ratios are cut in half, has gone up by 70%. Earnings as a percent of men's already went up dramatically through the 70s and 80s, continued to go up another 15% in the 90s to today. The number of women-owned businesses, 114% compared to total of 44% overall, increased number of businesses. Women of color, 467% increase in businesses, while their rates and ratios of abortion have gone down by half. Law school, medical school representation climbed huge. Women in state government up 41%, 248% increase at the federal level, 380% growth on the federal bench. All while abortion rates and ratios have been plummeting. In short, it's impossible even to show a correlation between abortion and women's progress, let alone causation. My final thought, in my view, legal abortion advocacy, especially its equating of legal abortion with women's progress, confirm public and private actors' inclination to refuse the expensive and complex strategy of accepting women into society with their children and with their desire to care for their children. They promote the male childless norm as the norm that everybody can expect. And I know it's a little better than it was, but I can tell you my own experience at a large firm, et cetera, it ain't easy, okay? Treasury Secretary Janet Yellen and other leading women economists have pointed out that the U.S. lags behind all advanced economies in providing support for women and parenting, okay? And I think abortion has been the get-out-of-jail-free card for people who have refused to do this. So, sorry I went on so long. Thank you, and I'm done. Thank you.
Good. So we'll come back, and you'll have plenty of chances to ask Helen any follow-ups you have. And I imagine there might be one or two lawyers here, but most of you aren't. So I just want you to understand the stance, the legal kind of stance. So the question is there a constitutional right to abortion, which is what we're looking at. And Helen gave a pretty good, I mean not pretty good, an excellent analysis of why there isn't really no constitutional right to abortion. It's in a, you may not know all these terms. The due process clause is a clause that says no state may deprive anybody of life, liberty, or property without due process. That's the due process clause. I didn't hear the word abortion. I didn't hear any of that. It's in liberty. And liberty, defined by Justice Kennedy in Planned Parenthood v. Casey, is the right to define the meaning of the universe and your place in it. Does that sound like a strict legal standard? Well, Justice Scalia kind of made fun of it as the sweet mystery of life passage. Why does that matter? Because you are citizens in a democracy. To the extent these judges take this issue, they take away your vote and your work here on Capitol Hill. A judge who purports to tell you what the meaning of liberty is without a strict definition like Helen was talking about, our tradition, is it clearly in our tradition, or is it necessary for the principle of ordered liberty? Those are strict standards. What the Supreme Court has done is said they can define it with their own evolving concepts of dignity, meaning, life, happiness. Look at the Constitution. I don't see the judicial role defined that way in the Constitution. The Supreme Court has a very modest role in the Constitution. You should insist on the Constitution because you are citizens here and you are being deprived of your rights. If Roe is overturned, the only thing that will mean is that you get to exercise your rights as citizens in different states and as federal legislators. Do you want to prohibit abortion in Virginia or Maryland, or do you want to try to prohibit it at this federal level? It's going to be very active, and I think the Supreme Court will uphold Mississippi, which is a 15-week ban. I'll say more about that in just a second. But it may, and looks like, I mean, my best guess right now is it will overturn Roe. And if it does, then you are re-enfranchised. But you're not going to be able to take it easy. You're going to have to be active because it's going to be an issue now in every state. So let's say the Supreme Court, so you've heard Helen's argument and why it's not kind of in the Constitution. What if somebody says to you, well, that's true, but it's an international human right. So here's the human rights part I want you just to be aware of. Not true. So there is no international human right to abortion. And how do I know that? Because there are only two ways you can have an international right, an international legal right. One is in a treaty, and one is by custom. Almost all international obligations are defined by treaty. Why? A treaty is written. It's a written document. It has certain terms, and it says you can do this or you can't do that. So any state knows what it's agreeing to if it signs a treaty. And the most important thing to remember about international relations, and we're in the foreign affairs room, right, is these are sovereign states. Every nation is sovereign. That means they have all rights that they don't give up. So if there isn't a treaty that gives a right to abortion, there is no right to abortion internationally unless it's custom. Custom, though, is very, very limited. It means all the nations of the world agree to do this, even though we didn't put it in a treaty. And that makes sense because nations don't give up rights unless they're written. So there's very few customs that are universally agreed upon. Now, if you wanted to argue that abortion was an international right under custom, you'd have to show unanimity. Not that, say, Britain has a right to abortion or France does, because they can do that. The argument is a country that doesn't have explicit recognition of abortion bound to recognize abortion under international law. And if it's not in a treaty and it's not by custom, the answer is no. So how do I know there's no customary international right to abortion? I could give you 100 examples, but the one I'll give you is just 2 years ago, there was something called the Geneva Consensus Declaration that the U.S. administration and 30 other countries issued. And it said there is no right to abortion. So remember, to have custom, everybody's got to agree. All the nations have to agree. And I've just given you 30 who says right now there is no right to abortion. So there can't be the unanimity for custom, and there is no treaty. So there is no international law right to abortion. But like Helen also mentioned, in some of these cases, Justice Kennedy in particular would say, well, I don't know if it's a right, but, he'd refer to values we share with a wider civilization. Again, you don't want a judge who's going to impose law on you based on his evaluation of values we share with a wider civilization. I don't think you do. I sure don't. So you might say, well, so Kennedy in the juvenile death penalty case and in other cases made reference to that to bolster his findings. But so let's say you were persuaded by that kind of approach. Well, the fact is most nations of the world are much more restrictive on abortion than the United States. Overwhelming. And in the countries that do have elective abortion like we do currently, the general rule is they limit them very strictly at 12 weeks. Mississippi's at 15 weeks. So and Helen mentioned her brief, and this is a brief I was on. The one I was on is a brief of 141 international law scholars. You can get that. I think you might even get it through the Faith and Law webpage, but at least you can find it. Brief of 141 international legal scholars, or Helen's, the brief she's on, brief of 240 women scholars and professionals and pro-life feminist organizations. So you can look in this brief, and so obviously time is a constraint. I don't want to be too complicated. If you want to dig into it more, you can look in her brief, you can look in my brief, you can find the sources and the information. So even if the Supreme Court and we thought it was legitimate to look at what the rest of the world is doing, the rest of the world is more restrictive than we are, much more. And it doesn't really matter whether they ban abortion. The question in the case is, should Mississippi's restriction at 15 weeks be upheld? What we said in the brief is, if you look to a wider civilization, even nations who permit abortion restrict it strongly, very strongly, at 12 weeks approximately. So Mississippi is fine. I mean, it would be bizarre to say you look at the values shared with a wider civilization and strike down a state law that is more lenient than what most states do. Anyway, I hope you followed that. If not, I can go through it again in question and answered. But the bottom line is, it's clear there's no, under the Constitution, no fair interpretation of the Constitution, unless you want judges free to put into their interpretation whatever they think the world should be. And I don't, I would insist it be specified in the Constitution if such were the case. There is no international right either. So I expect we will have a major win for the pro-life cause in the Dobbs case. And if I'm correct, you're going to be very busy staff people and citizens after that. So, Helen, anything that you want to say before we open up questions?
I think I said a lot already.
Okay, all right. So we'll get ready. Lauren is going to...
You ready for the Q&A?
Yeah.
Great. Well, let's open it up. Thank you. That was absolutely terrific. I know this is very important to a lot of you, this issue. A number of us came to Capitol Hill specifically because we were passionate about this issue. And so I'm really glad that we could have this time today in this really important moment in the history of our nation. I think, Bill, did you have your hand raised? Yes, you can.
First of all, thank you both so much for all you've done in this important area. I know it's been costly, and we're grateful for your leadership on this. Question for you. Before 73, Roe and Doe, there were 600,000 legal abortions in 1972. We can talk about that. And let's say we're at 7 or 8 or 9. I have posited that the abortion rate with a successful complete overturning of Roe and Doe, the legal abortion rate would drop back down to around 600,000 range. If that happens, how to get down to 0?
Right. Bill, I'll start, and you can, any of your thoughts? Because the feds have never required collection of this data, again, it's just fascinating to me that the issue is an obsession in a sense, and yet we really don't have good data on it. That number is out there. I'm not sure we know that it's true, right? We know Bernard Nathanson, who he and Larry Lader founded, the National Abortion Rights Action League. They made up all kinds of numbers. How many abortions there were, how many women died, and they were very explicit, or Nathanson became very explicit after he became pro-life, after doing, I think, 70,000 abortions, including his own child. And he said, we just made those numbers up out of whole cloth, okay? So we know, though, that there will always be some, and we certainly know that there's states, I've been testifying in some states or doing some work, and it's depressing. Vermont, I mean, they're not just talking about legislation, they're talking about sticking it in your constitution. Thinking about who you are as a state, and this is in it. It's just very depressing to me. Vermont, Illinois, New York, Massachusetts, a couple of, it's not going to be a tiny number of states. Let me just say to those of you, Kansas, Michigan, I think are some of the first 2 votes after this, Kansas in August, Michigan. If we win, which I agree with Bill, I think we will, and then we drop in 2 states like that, it will be horrific. It will be like we worked all these decades and then really didn't get it done at the state level. You know, everybody has to care about Kansas. Everybody has to care about Michigan. We can't be, it can't just be about our own state here that we're working on. We really have to send money and people and efforts into those states. So how to reduce the numbers? So, you know, it's not just what we call crisis pregnancy resources, right? We think we have, you know, 2,300, 2,700 crisis pregnancy centers in the United States. It's wonderful efforts. If we could get anyone in the pro-choice movement to assist us in that work, that would be terrific. Right now, the pro-life movement is really running this. Think about if we could increase our efforts on that, and I think inviting them into this would be terrific. It is also culture. And, you know, I wrote a book, came out 2017-18, it's Cambridge University Press, called Putting Children's Interests First in U.S. Family Law. And my argument is that unless we remind people that children's situation is created at conception, meaning the situation in which they will face life, will they be welcomed or not welcomed? Will they be with two parents who are ready to take care of them or not? So contraception has, you know, unintended pregnancy rates have stayed about the same or gone up or down a little. Contraception hasn't done it. Crisis pregnancy centers haven't done it, despite the thousands of them that exist. It's also culture. It's a question of people being sexually responsible to know that they're putting a child in a particular situation. I mean, yeah, some people marry after a child is conceived. Not a lot anymore, if conceived out of wedlock, and then those marriages don't tend to last quite as long. I don't want to scare anybody. This is just the on average, right, situation. So I actually think we have to ask people to be sexually responsible and to think about the child. And the book is an attempt to say that we've tried other methods. We've tried, you know, we put adults' decisions at the front door, and then we say, oh, when the child is at a crisis, then we'll start developing. And the most boring chapter ever written in a book, I think, was just listing all the government programs that attempt to help children at the back door. And not a lot of them really have a lot of data to show for them. You know, Head Start is like, yeah, some places it's okay. You know, great as the concept is, you know, the nurse-family partnership, maybe, okay, maybe that one's got some data to it. Moving to Opportunity, okay, maybe that one's got some data on it. Most of them, not so much, okay? We really have to get people to stop just thinking about adults at the front door and putting children at the front door. And just saying, think about the situation you're putting that child that you're creating into. I just think it's a culture change as well. The churches have to have a big role in it. And just, it's a secular thing as well. It's a legislative thing to help people think. And I propose a couple things in the last chapter of that book about helping people think about the child as part of an adult relationship from the beginning.
The only thing I would add is, you know, the basic teaching from Aristotle is that the law is a teacher, and it's very important. Law and culture, law and culture, law and culture. I don't agree that culture, law is downstream from culture. Culture and law, culture and law. They reinforce and they influence one another. So the laws need to be appropriate and just, and that will help influence the culture. Ultimately, people's hearts have to be changed. But I don't want anybody in this room, I'll just tell you, don't be discouraged. I mean, I imagine it's extremely difficult on the Hill, but with the conversations with people who disagree. But I mean, I know, you know, in my own case, when I learned facts about American legal history and what Helen was talking about, I mean, at the time of the 14th Amendment, almost every state was pro-life. So how in the world can you tell me that the meaning of the 14th Amendment is abortion? I mean, the states were all pro-life. I didn't realize it. So people don't necessarily realize it. So I think reasoned conversation outside of a super politicized exchange can still persuade people.
Questions?
Hi, Helen and Dr. Saunders, something I heard you say, Helen, a couple years ago that has stuck with me. It was amid the fallout of Me Too. I think it was near the time of the anniversary of Paul VI, Humanae Vitae, was that a dominant trend in the law is that there's this valorization of what you were just saying there, of adult desire over the needs and the rights of children. And so to that end, with what Professor Saunders was just saying about how the law is a pedagogical teacher, how do you see the likely reversal of Roe contributing to that shift away from valorizing what adults want to do sexually to prioritizing the precious kiddos?
You know, there's a great principle of public communications, and I mentioned it, I was talking earlier outside, is don't tell people what you know, tell them what you want them to think, right? Don't just blah, 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 what you know. What we want people to think, which also happens to be true, otherwise this would not be faith in the law, is I like Professor Saunders' emphasis on this gives you your vote back. But I also like the idea, tying it to a factual cultural point, which is this is reminding people of the child's existence. This is just reminding them of the child's existence again. It was sort of, Roe just kind of wiped that. It all was about the woman. And this is saying a right to take a life before birth is not in the Constitution. But it's going to be really pretty ugly out there if this comes out in June, as they usually do, toward the last week of June or early July. And, you know, you really have to be quite excellent. You can't just be good at communicating or talking about this. You know, I think Professor Saunders' point about this gives people in the States the opportunity again to speak out is the #1 thing to remind people of. And second is to say, you know, I hope we can have a more, it's been, you know, the other side has had, you know, all 100 yards of the field pretty much for so long, that to say, I hope we can have, and this is when telling people what you want them to believe, I hope we can have a reasoned conversation, that there has always been a struggle between a desire to respect life and a desire to help a woman in a crisis who feels that this is, that this has always been here. It's been completely just painted over with the right to abortion. And now that that's not there any longer, I'm just so delighted that we can have a real conversation again, even if they have no intention of having one. You have just pronounced yourself delighted that that's what the two of you are about to do. And I really do think that's important to set the table and have that conversation. I can tell you, in so many of the debates that I have, I had a debate at Scalia Law a few weeks ago with a woman who was a Sotomayor clerk. She's a visiting professor at Howard University Law School. And she really didn't meet the arguments at all, in my view. I mean, she's a lovely person, obviously really, really smart. But her argument was that the 14th Amendment was about giving liberty, in particular to Black Americans, therefore abortion, to free the body. I noticed that Andy Koppelman, who I think is at Northwestern, his argument is that we have to be for legal abortion because anything else would be to enslave women. So it's interesting to me that the arguments are just like, they're just not even touching the question of the life on the other side. It's as if they haven't had to for so long and they can't afford to have that conversation any longer. But don't let them do this, right? To say we recognize, you know, the woman is struggling with the pregnancy, but that there's just simply no doubt in any embryological textbook, in any of the top 10 or any of the other medical schools in the country that we're grappling with human life, can we just be intelligent about this?
Yeah, I'll hold. You get somebody else.
You mentioned issues with the NIH in your comments, and as you know, Dr. Francis Collins is a Christian, but seems to be carrying water for the abortion regime in this country. What would be your response to Christians in the public square who seem to be doing that?
Yeah. So I guess my first response is that I hope someone's talking to them privately, right? That way that Christians should talk to each other. I have a brother who's, I'm one of 5 kids, and my brother is an evangelical Christian. And he recently wrote me a note just saying, you know, that we're on the same page about so many things, and that he wants to be assured that I have done and thought and said certain things vis-a-vis Christ in my life because he loves me so much that he wants to be sure of these things. And we had this marvelous exchange because of that. I have friends who tell me when I've fallen off the nice wagon, right? And I need to get back on, and I need to shape up my prayer life, my fasting, my sacrifice, etc. My first response is actually that I hope he's got some good Christian friends who are explaining to him that this is actually kind of cataclysmic. I mean, I remember, it's a long story, but I was setting up an ad in the New York Times, and I took a line out that I thought was unkind. It was a pro-life ad, and the New York Times made a mistake, and it went in there. And someone came to me, and this was years ago, and just said that, you know, they had lost all their respect, and that this was a low blow, and I was glad they came. I explained to them it was a mistake. I cried, you know, in my office with this person. And that I had let down the movement and this. And so, and then every once in a while, I also think you need someone who speaks in a loving tone, who just says, you know, I'm not quite sure that he realizes quite how cataclysmic this is, to like a fundamental principle, right? Love God and one another with a good Samaritan kind of love. And we're talking about, and in the case of fetal tissue, embryonic stem cell, et cetera, you're really talking about a violent abuse of the human person who God has made. And and you said, I hope, Dr. Collins, you're hearing this from your friends, but in case you're not, I say this to you, you know, in a Christian fashion. But it's got to be said.
All right, we are almost out of time. I'm going to let one more question happen back here, and then we're going to close it out.
Thanks. This goes a little bit beyond the pro-life question at hand, but you'll hear some commentators, particularly on the left, say that if Roe is overturned, other decisions relating to contraception, Griswold, Obergefell on gay marriage would also be jeopardized because they rely on the same shaky foundations. Do you accept that argument, and just what would be the implications of a domino-like effect?
Well, I mean, so I'm a lawyer, obviously. I mean, the case is, they're not going to go beyond abortion in the case. So the question is, will the case be decided in a way of judicial decision-making that's good, or will it be this kind of living constitution where unfettered judges without fetters interpret terms that are hundreds of years old? And it may have an impact on that, but each of those other issues you mentioned would have to be raised in subsequent cases. It wouldn't necessarily mean it.
Yeah, I agree with you that the shaky substantive due process that undergirds one undergirds the many. I think, however, that it's my educated guess that the court does not have the stomach to overturn Obergefell. But there's been 50-some years of unrest regarding Roe, and they have the stomach. And I think that's, substantive due process-wise, there would be some similarities between overturning both.
And one little quick comment, Christian to Christian, you know, 2 wrongs don't make a right. I mean, in other words, the argument that we would lose X because we would remedy this great injustice of abortion, it's a very weak argument. And it's also not an argument made by somebody whose life is on the line. That's one thing we should never forget. I mean, the unborn can't speak, and their lives are taken. So do you believe American democracy is founded on a principle where innocent people can be killed because it's convenient for other people? I don't. And no argument has been made, as Helen tells you, that it exists in the history of this country.
Well, thank you so much. I wish we had more time for Q&A. They will be around. And you're welcome to come up and ask your questions. And we will, at Faith and Law, there's really only one issue that we take a complete policy perspective on, and we truly believe that the Bible is very clear on life. And so we will continue to have these kind of sessions and opportunities for you to ask questions and deeply engage this issue. So thank you so much for being with us today. And now, Father Gurney. Father Gurney, it looks like a priest right now, which he is, but guess what? He used to be a Capitol Hill staffer attending Faith and Law. So we're really glad to have him here and giving the closing prayer.
Thanks, Lauren. Let us pray. Almighty God, we recognize that we are endowed with the right to life from our Creator, from you, and yet some don't see that. Some miss that basic truth. We thank you for Helen and for Bill and for their great work, for their hard work, for their passion, for their zeal. Help them to inspire the people in this room and throughout this hill. May this hill be a bright light on the city. May all people come to know that you are Lord and that you love us and that you have given us life, and that must be respected. We ask all this in your holy name. Amen.
Amen.
Thank you. Thanks.
Hope to see you all next week.